Hello and welcome to GLJ Specials. My name is Nora Markart and I'm an editor of the German Law Journal. In our third episode, I'm very pleased to welcome Boris Burghardt. He's a visiting professor for criminal law, criminal procedure, and legal philosophy, and Leonie Steinl, who's a senior researcher and lecturer in criminal law, both at Humboldt University in Berlin. Today, we are talking about the special issue they put together for the German Law Journal, entitled Sexual Violence and Criminal Justice in the 21st Century. Welcome to GLJ Specials. So what motivated you to do a special issue on sexual violence and criminal justice?
I think we've both been working on sexual violence and criminal justice for a couple of years now. And me personally, I think I've been interested in this as a student and then later as a scholar who was particularly interested in criminal law on the one hand, but also feminist legal theory. So then, of course, sexualized violence is a central topic in these areas. And initially, I mostly worked on it from a legal policy perspective. So as part of the German Women's Lawyers Association, which lobbied for a reform of the German criminal code and its laws on rape and sexual violence in order to ensure that it's actually in line with international human rights standards. And this reform was really important, which happened in 2016, because it ensured a better protection of sexual autonomy in the German criminal law. And then Boris and me together started working on an article on the new offense, which was also created back then, on sexual harassment. And we found this really interesting and really thought there were a lot of open, important questions which were unaddressed at this point, and which didn't only concern criminal law dogmatic, but also were really relevant from a socio-political perspective and from a gender perspective. And so we realized this is just one topic, and there were a lot of other topics that we also wanted to work on. And I think Boris had the idea of applying for a special issue with the GLJ.
Yeah, that's right. I just felt that there were so many interesting debates going on so many different levels with regard to sexual autonomy and its protection through criminal law. In many legal systems, the law on sexual violence has been reformed within the last decade in order to better reflect our changed understanding of sexual autonomy and what a violation of sexual autonomy is. And we can perceive the shift from a criminal law that is primarily interested in protecting a collective idea of decency, moral decency, to a criminal law that intends to protect individual sexual autonomy. And on a societal level, as Leonie already mentioned, there was Me Too and similar social media-driven movements shaping our consciousness of how pervasive sexual violence really is, and how insufficient maybe also the legal answers to these problems are. And then in a number of states, you had massive public outcry over egregious sex crimes and the perceived lack of adequate responses of the criminal justice system, for example, in Spain and India. Then you had debates and calls for criminalization of newer phenomena like upskirting, for example, or revenge porn, catcalling, that also address questions of the limits of criminal justice. Then we have on an international level the Istanbul Convention of the Council of Europe on preventing and combating violence against women and domestic violence, which raises questions of possible state obligations to adapt their criminal law to international obligations stemming from the convention. And from our view, all these debates weren't really reflected in academic discussions, at least not in the contributions of German criminal legal scholars at the time.
You put together, though, contributions not just on the German debate, but you've included contributions on Sweden, on India, on the international debate, on Spain. How did you select those contributions?
we try to narrow down all the interesting issues to broader overarching questions that could structure our special issue. And in my recollection, we agreed rather quickly on 3 sections that seemed absolutely key to us.
And I think what was also really important to us was to, since we're both criminal law scholars, of course, we have this focus on criminal law, but we definitely didn't want to limit the special issue to criminal law. So we were looking for constitutional law perspectives, human rights law perspectives, international law, but of course then outside legal academia, also sociology, sexology, and so on, which are really important. And then legal gender studies, feminist legal theory, and not just academia, but also practitioners and activists. So to include all of these voices. And the first section of our special issue is called Sexual Autonomy and the Consent Paradigm, which I think is some of the most fundamental questions in this issue. And they sound pretty straightforward. So sexual autonomy, it seems like a concept which everyone kind of understands, or at least we know, rape is a violation of sexual autonomy. But then when you start to think about it, you realize it's actually quite intricate. And for instance, what is rape by deception? Is that then also a violation of sexual autonomy, or under which circumstances? Or rape in a video game, for instance? Or what about things like catcalling, verbal sexual harassment, sexualized hate speech, upskirting, revenge porn, all of these different forms? Do these behaviors also constitute violations of the right to sexual autonomy? And also the consent paradigm is not as easy as it seems. We already see, we have approaches like no means no, like in Germany, but then in Sweden, for instance, we have yes means yes, which is a different form of consent or a different understanding of this. So that's what we're looking at in the first section.
So then there's the second section on sexual violence and the limits of criminal justice. And for this section, we were looking for contributions that addressed the problem of how a gender-sensitive concept of sexual autonomy and the consent paradigm can be translated into criminal law without losing sight of central liberal ideas of a limited role of criminal law, that criminal law isn't always the proper answer to address wrongdoings, and that it should be limited to very central and maybe graver violations of fundamental individual rights. So basically the idea for this section was, even if we do understand that a certain act violates sexual autonomy of another person, what are the limits of addressing this violation by means of criminal law? And then the third key issue that seemed indispensable for us for the special issue was the influence of social movements, because this is really one characteristic of the legal debates around sexual violence in the last years, how far it transcended the institutionalized political sphere or legal sphere, these debates, and how massive the influence of societal movements was.
And there we're looking at things like the Me Too movement, of course, but also in specific countries like India and Spain, where there were individual, really drastic cases of sexual violence, which sparked large-scale protests, which then led to reforms. And we're also looking at Germany in this instance, which, we've had for a really long time women's rights groups and also some scholars pushing for law reform with regard to sexual violence. But then only with the events of the infamous New Year's Eve in Cologne did conservative actors, by using also some racist narratives in a very problematic way, jump on the bandwagon. And only in this case did we then actually come to this reform of sexual violence laws in Germany. So that's what we're looking at in this section.
Yeah, and I mean, the fourth section is maybe less obvious, but rather a result of our maybe more personal research interests, because both Leonie and I have been working in the field of international criminal justice for years now. So the fourth section is dedicated to international criminal law, sexual violence in international criminal law. But of course, there are also more objective reasons to integrate this area as well into the special issue, as there have been very interesting and relevant developments within the International Criminal Court. which has become over the years much more sensitive to the gendered questions of prosecuting sexual criminal violence, and as well within the German judiciary and prosecuting international crimes. So we have also two contributions that center around these questions.
The special issue really opens a big panorama on the topic. Nonetheless, can you tease out any sort of maybe main findings or central motifs that you think sort of crosscut all these contributions?
I guess one key issue that came up in almost every contribution, and is definitely one issue that we are both still struggling with, is the proper role of criminal law in the protection of sexual autonomy. Can the repressive grammar of criminal law have emancipatory effects, not only punish individual perpetrators, but also kind of break up power asymmetries with regard to broader societal relations. This is something that we are still grappling with, and I think one central learning of the contributions we received for this the special issue was that much depends on the larger conditions within in which the criminal justice legal system operates. What are the sanctions that are imposed? How independent or how racialized is the judiciary? What are the how strong are the procedural safeguards for the accused? So this is one thing I would mention with regard to the results that we're taking from this special issue.
And I would also add that there's actually still a lot of space for scholarly engagement or discussion from different legal systems. I think especially in Germany, discussion is very much happening only in Germany on like German sexual violence laws and so on, and not so much informed by, for instance, even other European countries. And I think that was really interesting to us to have all of these different contributions, and we're trying for that. And I think for one issue that we both of us found particularly interesting, and also now working on another project, for instance, is the non-physical dimension of sexual violence. So looking at these phenomena like image-based sexual abuse or verbal sexual harassment and so on, and see under which circumstances do these behaviors constitute violations of the right to sexual autonomy, and when is criminal law the right response to these violations. So I think that's something that we found particularly interesting.
About you, who would play you in a movie?
Well, it has to be an actor with strong, thick, dark hair. So, I mean, Stanley Tucci wouldn't be a bad choice, I guess. He encompasses humor, but also goes for serious roles. So Stanley Tucci, I can work with that.
What would you have become if you hadn't gone into academia?
I would have worked for an NGO, because that's what I did before. And I also really liked, and I think it's similar to academia in some ways, the work you do. But I choose academia because there you can choose your own topics and your own opinions, of course. And so I think it's even cooler. But the NGO world is also really interesting. And I think especially coming from international criminal law.
Thank you very much for being a guest on GLJ Specials. And we're looking forward to hearing more about the individual contributions from this special issue.